So this is our third video in this series of the war on terrorism and what the president and Congress can do. So something that you need to know about is something called the writ of habeas corpus. And writ is spelled W-R-I-T, and habeas is spelled H-A-B-E-A-S, and corpus is spelled C-O-R-P-U-S. And what habeas corpus means in Latin is that you have the body. And what a writ of habeas corpus means is that you, wherever you're being confined, have a right to physically have your body produced, so let me see the body, and be told why you're being confined. Now this is in the US Constitution. It's in Article 1, and remember Article 1 is about Congress, Section 9, Clause 2. And this is called the suspension clause, and it's about when Congress can suspend habeas corpus. And it says, the privileges of the writ of habeas corpus shall not be suspended unless when in cases of rebellion of invasion, the public safety may require it. And so again, under the suspension clause, Congress can say that we're in a time of invasion and we're suspending the writ of habeas corpus, but the president can't, okay? This is a power of Congress, and that's why it's gonna matter in the next cases. And also why it did matter as a secondary matter in Hamdan, which we just read a video about, because it was the president, George W. Bush, who was suspending habeas corpus, not Congress, okay? He was the one who was saying that these enemy combatants can't be seen. So, what we end up having in our next case, which is Hamdan versus Rumsfeld, H-A-M-D-A-N. So in Hamdan versus Rumsfeld, what we have is that the decision in Hamdan, right, said that you can't just hold people forever. So the executive branch, which is the president's branch, so George Bush made up this thing called a Combatant Status Review Tribunal, a CSRT. And the CSRT, as we're gonna go through in this opinion, is very different than a court of law. There's a lot of different things that you don't get in these tribunals that you would get if you were in a regular military court, or if you were in just a regular court, like if any of you were charged with something and you went to a federal or state court for committing a crime. And what happened was Mr. Hamdan was found under one of these tribunals to be an enemy combatant. And once you're an enemy combatant, you would just be held indefinitely until the war on terror ended at Guantanamo Bay. So he's held at Guantanamo Bay. So he filed for a writ of habeas corpus, which means, again, show me the body, so that he would physically be able to go to DC. He filed it in the federal court in Washington, DC, and said, you need to hear my petition. Someone needs to tell me why I'm being held, and I need to have a chance to fight against that. And while this was going on, Congress passed the Detainee Treatment Act, or the DTA, which said no one in Guantanamo Bay is allowed to ask for habeas corpus anymore. So that's what was going on here. So there was two issues, basically. What are we, like, can he even ask for habeas corpus here? And if he can't ask for habeas corpus here, are the tribunals that the Bush administration set up sufficient, or are they not sufficient? So what we end up having here in the case is that Mr. Hamdan was Osama bin Laden's bodyguard and driver, one of his bodyguards, and one of his drivers. He was arrested in Afghanistan, as I said, being held indefinitely until the war on terror ends at Guantanamo Bay. And it was determined that he was an enemy combatant. And he wanted to challenge this for a variety of reasons, including because he was a chauffeur and drove a car, and in addition to many other reasons, said that this isn't a combatant. Someone who drives a car isn't in war and isn't fighting if you drive a big fancy car. So what you end up having is a decision that these tribunals were not okay. Now, these tribunals were not okay for three main reasons, according to the Supreme Court. Oh, and as an initial matter, the Supreme Court decided that the Detainee Treatment Act, the DTA, didn't apply to people before. So they could still hear his case and they could still hear his writ of habeas corpus because he filed it before the law happened. And laws in this country take effect after, right? So if you do something and it's not currently against the law, under the US Constitution, it's not allowed that people pass a law and then make it illegal afterwards. So it's the idea of no ex post facto law. So the court was sort of applying that here and saying that since he filed his writ of habeas corpus before the DTA, we can still hear his case. And we can decide later whether or not we can hear future people's cases. So the main things that are wrong here that the Supreme Court said needed to change is that the attorneys and the defendant couldn't see certain evidence. So if the government said evidence was classified, the defense attorney just couldn't see it, and the person who was charged couldn't see it. And sometimes the defense attorney could see it, but he wasn't allowed to tell his client. So, of course, that's very problematic, right? Because if you don't know what a charge is against you, how are you ever going to be able to refute it and prove that it's false? And then the second problem is that any evidence could be admitted, including hearsay, including testimony that wasn't sworn. So normally in a court of law, you have to swear you're telling the truth. You didn't have to swear you're telling the truth. And testimony gathered through torture and statements gathered through torture, which is problematic because we don't want to be torturing people, but also problematic because, as we know, people confess to things under torture, not because it's true, which is they just want torture to end, which is why in courts, typically, so if there was duress or torture for your statement, then it can't be used against you. And then third, the appeals weren't heard by courts. The appeals were heard by the executive branch. So the tribunal already is just in front of the executive branch. And if you want to appeal it, you're still just before the executive branch. So courts never got part of it. It was just always under the president, every single part of it. So the government said that these things needed to get better. So that's where we were after the Hamdan case. And we have one more video to come.